Hi, my name is Stephen Bonfa, and I prepared this short video for you to get a bird's eye basic understanding of what goes into an estate plan, things that we have to consider, and some of the strategies that we can employ. I'm an attorney. I have an LLM in taxation, which is a master in laws, and my focus now, despite a very varied career, is focused on estate planning, elder law, and tax. I am currently a partner and I'm the head of the Trust, Estates, and Tax Division at IX Legal. IX Legal is a multidisciplinary law firm that helps various clients through various disciplines, trust and estates, corporate formations, there's litigation, there's real estate. So we do everything here at IX Legal, but I am the chairman and head of the Estate and Tax Division. So whenever someone comes in to my office, I like to say there are three buckets of planning, which is the areas of focus that we talk about in order to get an understanding what goes into your estate plan. The first bucket is who gets your stuff. The second bucket is whether or not we have an estate tax consequence. And the third bucket is whether or not the client is interested or you're interested in long-term care Medicaid planning. So if you have a medical condition and you want the government to pay, we go into how we can protect assets. The first bucket, who gets my stuff? Okay, we need to get an understanding of who your heirs are, who you want to be your beneficiaries. We can name beneficiaries to your accounts. We can change ownership. We can create an estate plan that gives specific gifts like $50,000 to your favorite attorney, Stephen Bonfa, or $20,000 to St. Jude's Hospital, etc. But typically, we find most of the estates is run through the residuary clause, where you say everything to my spouse or 50% to each of my children equally, etc. And then we also like to talk about who you don't want to give your inheritance to. So if you have a bad apple on your family tree and you might want to make sure that worm does not participate and is able to get anything, we talk about that as well. I want to point out if you do not have an estate plan, New York State has an estate plan for you, and it's with they determine who gets your stuff and not what you determine. So I would rather you pick than New York State. The second bucket is whether or not you have an estate tax consequence. So right now, for the federal government, if you pass away in 2026, if your estate is lower than $15 million, then you do not have an estate tax consequence. If you're over $15 million, then you will have an estate tax consequence and you will be taxed on the overage. So if $16 million, you'll be taxed off of that $1 million overage. New York State has a lower threshold. New York State is if you pass away this year in 2025, the threshold is $1.76 million. Next year, it's going to change in 2026. It's going to adjust for inflation. So we're estimating it to be 6.5 or 7.3, somewhere in that range. But New York has a wrinkle, unlike the Fed. Unlike the Fed, if you are over a certain amount by 5% of the exclusion, then you're not just taxed on the overage, you're taxed on dollar one. So if someone passes away in 2025, if your estate was over $1.5 million, then the entire estate gets a 16% tax rate, which can be crippling, crippling. So there are different ways that we can plan to eliminate or reduce your estate tax. One is something we call a credit shelter trust. And what that does, it preserves the first spouse's exclusion, passes it to the second person. And then when the second spouse passes away, that exclusion is taken care of. It's very plain vanilla. It's a very great way to exclude and reduce your estate taxes. If what's pushing you over or getting you near the limit of the exclusionary amount is a life insurance policy, so you have $1 million life insurance policy or a $500,000 life insurance policy, then we plan and we exclude that life insurance policy from your taxable estate. Uncle Sam doesn't care where someone is making money for. Uncle Sam feels, and New York State feels, if someone's making someone somewhere, they deserve a piece of the action. And if it's life insurance, then we can help shelter that life insurance. You can make annual gifts without having to do a gift tax return. And currently it's $19,000 for 2025. You can do charitable gifting. We can make a private foundation for you when you pass away. There's lots of stuff we can do with that, especially if you're already charitable minded. And then there's other things like a grant or retained trust that we can do to help you eliminate or reduce the estate tax. Finally, we'll talk about Medicaid asset protection. Medicaid asset protection and Medicaid, long-term care Medicaid, is a federal program administered by the state. So New York State has different rules than Connecticut and New Jersey or Florida. So this is the New York rule. Okay, if you have assets and you're considered above the poverty line, and Medicaid sets what the poverty line is, then they say you have to pay your own medical bills. However, in New York, if you're a single person, if you make an income of over $1,800 a month, you are not eligible. If you have assets as a single person up to $32,396, then you are not qualified. You make too much money and you have too much assets. So if you are over these thresholds, you will not be able to get assistance. So if you have a house and you have an income, you might not be qualified financially to be able to get Medicaid to pay for your long-term care. There's something when we do Medicaid planning is there a look-back period? And that look-back period for long-term care in a facility is 5 years. So they'll get all your bank accounts and all the assets, everything you've owned in the last 5 years, and they'll see if you qualify under those parameters. If you are under the threshold, then that's great. If you're over the threshold, then that's not so good. And any transfer of asset you make within those 5 years, so if you make a $100,000 gift to your favorite attorney, then they will count that still. They assume that you made that for the sole purpose of becoming eligible. Right now in New York, there is no look-back period. When that's going to change, we don't know. But currently, if you have someone who needs care and they need an aide to come to the house, we can get rid of all the assets on one day and then apply for a home health aide service the next day. There is no look-back period. So now's the time to do it. That was instituted after COVID, so we don't know when that's going to change. And if it does change, it perhaps will be at most a 30-month look-back period or 2.5-year look-back period. It may be phased in, we don't know, but it's not going to be around forever. So now we have what can you do to spend down? So if you make over the amount, either in income or in hard assets like a bank account, etc., you have to spend that money down and then get to the threshold amount. So how do we do that? You can pay off debts. You can purchase medical devices not covered by insurance. You can make certain home modification and repairs. You can repair a vehicle. You can purchase an annuity with certain conditions. You can have a funeral trust or a prepaid funeral expense up to $15,000 per spouse. So there's some stuff that we can do to get some spend down. The second thing I'd like to talk about is what goes into an estate plan. Okay, there's the last will and testament. There's something that we call the revocable trust. There's an irrevocable trust, and there's some other planning. So, and whether you do a will or a trust, there are several components that on it and everything. There's an identification and what your residences are. That's important because where you live, where your domicile is where the rules apply to. If you have specific requests, if you have personal property requests that you want to give to someone, your house, or you want to give to charity or your cousin or a friend of the family, etc., who gets the pets, that kind of stuff. Then we have the residuary clause, which encompasses everything else that's not a specific gift. We do have to plan for minors. If you're in New York, if you're under the age of 18, you cannot have ownership of items because you're considered to be a minor. You name your fiduciaries. Who's your executor? Who's your trustee? Do you have a minor that you have to have a guardian for? What are the powers of your trustee? What are the powers of the executor? There's other provisions, such as maybe you have to plan for someone who has special needs. Maybe there's someone who has drugs or alcohol. Maybe you want to plan for an IRA distribution. Then we sign it, and then we have the witnesses also sign a special affidavit. So here's a quick comparison of the different types of things that we can do. There's a last will. The positives are it's flexible. It could be amended. We can do your estate tax planning. We can distribute your property, and it's typically preparing a will is the least expensive option of these three. Some disadvantages of having a last will, it has to be probated. So you have to get the will, your executor goes to a surrogate's court, files that with a petition. It takes time for the court to get around to take a look at it. And then even after your fiduciary, your executor is appointed, there is a 7-month delay before you can distribute the entire estate or settle it. And there is no asset protection. So there's a Medicaid planning. There is no asset protection with regard to a will. You have to alert all your heirs whether or not in your will you say they get something. So there is notice provisions, and there is in New York, we're experiencing an 18 to 24-month delay before we can distribute the estate. So there is, depending on how New York goes or your state goes, there could be delays before everything goes out to your heirs. The second is a revocable trust. This you get all the advantages of a will, plus it avoids probate. You do not have to go through a court proceeding. You don't have to file anything, and you just move forward and you have your assets distributed. So there's a fast distribution of assets. You don't have to wait for an appointment. You don't have to wait for the court to review all the paperwork, and there is no court filing fees. And you don't, typically it's 30 to 60 days, depending on our situation, you can have your assets distributed. You retain control. You're the boss. You are the trustee. And especially if you're disinheriting an heir, what we call an heir at law or a distributee, it's much, much harder to contest a revocable trust than a will. There's no notice. We don't even have to send them notice that you passed. Some disadvantages of a revocable trust is it's typically more expensive to draft and put together than a last will. A revocable trust, although there's a myth about it, does not provide you any asset protection. So it doesn't protect anything we put inside that trust from Medicaid or creditors, etc. Okay. There's typically higher administration costs. There is an ongoing higher cost per year with a revocable trust. You may have a trustee that has a commission. You potentially in your tax return, you have some different papers you have to put into it. And if we don't do it correctly with a revocable trust, you can lose what we call basis. And basis is I bought the house for $40,000. I sell the house for $1 million. The $40,000 is the basis. And now capital gain is, in a very simplistic view, is $60,000, which could be a big issue, or $1 million, depending on the difference between the basis and the sale price. So revocable trust, we have to do this very carefully to make sure that we do get a basis adjustment. So if you pass away and you have your house and you bought your house at $40,000 and you give it to your children, and now her house is worth $1 million, if your children sell the house a day after you die, there is no capital gains. It gets wiped away. So we have to make sure that the proper terms are in the revocable trust to protect that basis adjustment. And finally, there's an irrevocable Medicaid trust. So all irrevocable trusts have a purpose, okay? This particular one we're describing is a Medicaid Asset Protection Trust. The purpose of it is to protect your assets from Medicaid. So it gives you the same benefits as a revocable trust, plus that Medicaid asset protection. And as I alluded to earlier, there's something called an irrevocable life insurance trust. And that has the same concept. It's irrevocable, but it's for a specific purpose. The disadvantages of a Medicaid asset protection trust is a limited ability to amend. It's irrevocable. It's unamendable. It's difficult or impossible at some points, but certainly it's difficult to make changes in that trust. There's a loss of control. Medicaid says if you have the strings of ownership, pull the string and pay for your own medical bills. So typically you are not the trustee. You have a child, you have a professional, you have your uncle, whomever, to be the trustee. Those assets inside of a Medicaid trust cannot be used by you for your benefit. So if you have $100,000 of cash or $1 million of cash in your Medicaid trust and you want to buy a car and go on vacation or pay your rent or pay your HOA bills or go into a senior community and have those things paid, you cannot get that out of the trust. Once it's in the trust, it's like the etched in stone. Okay, so it cannot be changed and it's stuck there. And there all again, it's a potential loss of basis adjustment when you pass. So we have to be very particular in what we say and how it's written to make sure we do not lose that basis. So if the primary purpose is a long-term care Medicaid planning, maybe a Medicaid trust is the way to go. So those are the different options. And when we get together and talk, we will go through them to see what best fits you and what you like, and the cost to see what you'd like to pay, and see what's good and what's not bad to your particular situation. Again, you're the driver. I am the navigation system. There's some other things that we can do to make plans in addition to or separate than a will or a trust, and that is a life estate. So a life estate means you put the title of your home in your children's name, but you as the parents retain what we call a life interest. So a life estate, you as the parent, you cannot be evicted. You cannot be charged rent. You need your approval, so your children or the owners cannot get a mortgage or sell the property without your permission. You are primarily responsible for the building, so you have to pay for the landscaper. You have to pay if you want to paint the house, if you want to, there's a plumbing issue, if you have to replace a boiler, you have to pay for the uh, taxes, you have to pay for the homeowner's insurance. Okay. However, if you're getting the different exclusions like senior exemption or a military discount or this enhanced star, it still stays and it gets only calculated by your income and not the other title owner's income. Okay, you do get a bump up in basis, like we said, when you pass away. So it eliminates capital gain on the date of your death. And here's the real good bonus with regard to life estates. After 5 years, it's exempt from Medicaid, or 2.5 years if it's a home health aid, but 5 years if you need to go into a facility. If during those 5 years you have to go, there is a reduced value within that 5 years. If your children are paying for the taxes, etc., they can get the deductions. If they pay, if you pay for the taxes and other deductible expenses, then you get it. So it's a very good plan. It's a good way to kind of hedge between an irrevocable Medicaid trust and not having a Medicaid trust, but there are also some disadvantages. Much like your children can't sell the place or get a mortgage without your permission, you cannot do it without their permission, okay, or whoever's on title. We find that life estates is difficult, in fact, to get a mortgage or a line of credit out of it. So you have to go to specialty lenders. So it's a little bit harder to do that. Uh, if your children have or undergo financial distress and they file for bankruptcy or they have a creditor, then those creditors say, hey, you have an asset. You are the title owner of this property, and they can go after their portion of the asset. Or if they file for their bankruptcy, then their portion is an asset in a bankruptcy proceeding. Or if they have your grandchildren applying for financial aid, they will look to the parents' assets, and could be considered their portion could be. If you sell during your lifetime, then there is a capital gain exposure. And if it's sold, this is the big one when it comes to Medicaid planning. If you sell the house, then that look back period begins again. So if you hold the house for 6 years, it's exempt. If you sell it at year 6 or 7 or 8, now that 5 year look back period begins again. You've turned an exempt asset into a non-exempt asset. So we do not use life estates in a Medicaid perspective if you're going to sell the house and move to Florida. So those are the advantages and disadvantages of that. So the other documents that we do in every one of our estate plan is one of them is called a healthcare proxy. Healthcare proxy allows you to pick out who makes your medical treatments. If you can't do it, you name someone to be able to do that. Then there's a living will. So in the event that you're in a persistent vegetative state and there's no hope for recovery, and you're only being kept alive by artificial means, this is where you say, remove the artificial means, or I want just be kept on respirators, etc. This is what a living will does. Then we have a power of attorney. The power of attorney, like a healthcare proxy, is someone who you pick to make your financial decisions. It can that power, the ability for someone to write checks on your behalf or speak to your IRA, etc. That can either start immediately, or you can pause it and say, well, they only have that power when a doctor certifies that I do not have the mental capacity. There's been some significant changes in 2021. So if you have a power of attorney that was executed prior to June, you may want to take another look at it because that law has changed. So what we can do, okay, you can also make formula gifts using your exclusionary amounts. You can make loans for family members, or we can make trusts like a supplemental needs trust for someone who has a disability, or maybe they can't handle money, or you certainly don't trust them to handle money. We can make trust for them as well. We can do trust, which is the credit shelter trust with disclaimer planning. There's Q-tip, which is spousal planning to be able to handle the estate tax burden. We can make certain types of trusts, intentionally defective trusts. We can do some charitable giving, and we can do 1031 exchanges for commercial property. So these are the different things we can incorporate inside of your estate plan to reduce or eliminate your estate tax uh, liability, as well as make sure your assets go where you want them to go and not have the government pick who gets your stuff. So hopefully this gave you a nice little overview with regard to estate planning. What are the basics and the fundamentals? So when we meet and get together, you can ask better questions and get an understanding of what's going on. So this is my contact information. Please feel free to reach out to me. Happy to talk to you. Happy to work it out. There is a solution to every situation, and I'm excited about helping people get to where they need to go. Thank you very much, and I hope to see you soon.